Buddy, hope you're doing well. Let's jump into discussing legal briefs, which we briefly discussed already, or at least you put some notes on. But today we're going to talk about the connection between legal briefs and the written opinions that the Supreme Court produces. So, what I want to get through today is um, just briefly discuss again what it means to influence the Supreme Court. Perhaps I'm beating a dead horse here, but influence means a lot of things, and we're going to talk about a particular type of influence today and why that sort of matters. We're going to see how that influence bears on opinion content and why that matters. Right? Opinion content ends up being a pretty important thing. So let's jump right into the paper you read for the day. A researcher, Pamela Corley, she talks about influence as having, quote, affected the nature and substance of the opinion, which means the briefs have influenced the law. So we're talking about briefs, we're talking about influence, we're talking about the law. All these things sort of come together to matter. She also writes, this does not necessarily mean that the party has influenced the decision of the justice, but it does mean that the party has influenced the development of the law. This is a great quote that highlights 2 points that I wish to make. The first is that influence doesn't mean that the justice has changed his or her mind. You do not have to get, let's say, Justice Brett Kavanaugh to vote in a liberal direction to suggest that you have influenced him. Instead, perhaps the most important thing when it comes to the Supreme Court is not actually the votes, it's the final outcomes, it's the law, it is the written opinion, right? There are infinite presumably infinite potential legal outcomes, right? Therefore, well, if we talk about set theory, right, there's an infinite set of liberal decisions and there's an infinite set of conservative decisions. So influence is somewhere involved in moving inside of that infinity space, creating a policy or convincing a justice to select this policy over this policy. To put it in a little bit more abstract terms, let's give an example of, let's say affirmative action. Okay, affirmative action, a liberal decision in affirmative action is to say all public universities, public employers are allowed to use race as a criterion for employment or for admissions or something like that. Another liberal policy would be race. There can be race quotas when it comes to affirmative action. So, for instance, 10% of students at every university need to be black or something like that, right? Those are both liberal policy outcomes, but they're very different outcomes. So when we talk about influencing the law or how a justice may be influenced, we're not talking about a liberal justice making a conservative decision. We're talking about a liberal justice deciding between the quota policy or the race as a criterion policy, right? Both are liberal, but the legal outcome, the final outcome is the same, even though the vote looks the same for both of those. I said that wrong. I'm sorry. The legal outcome is different between those two, even though the vote would look the same. It's a liberal vote from a liberal justice, for instance, but the policy, the policy matters. What is actually written in the opinion is different, and that's what matters the most. So again, no attorney, nobody needs to change a justice's mind to be persuasive. They just need to sort of guide them down the right path or their preferred path, right? Um, so Corley sees influence as the ability to persuade the justice to use your understanding of the law. It's not to totally change their mind. It's to say this is the best policy for the liberal direction or the conservative direction, whichever way you think. So to find influence, Corley does something that's pretty cool. She looks for plagiarism. She says that if a justice plagiarizes language from a legal brief when writing their opinion, that's a sign of influence. Um, it could be, though, that a lazy justice, or I prefer to think of it as a rational justice, just reduces his or her workload. They see an argument they like, so they just take it. But given Corley's concept of influence, right, that it's just persuading the justice to use your version of the law, it doesn't matter why the justice does it. It doesn't matter if they're lazy. It doesn't matter if they're rational or anything like that. It just matters that they do it. Okay? The fact that they use the same language is ultimately what makes a brief influential. But she uses plagiarism software, the same type that I would use when you submit papers on Blackboard, something like Turnitin.com. So when you submit papers to me, I can see the percent of matching text between your paper, between other students' papers, between other students at other universities, and between 20 million other papers and writings that are on the internet. Now, most of the time, it's nothing. It's, even up to 25% copied. It doesn't mean that you're plagiarizing necessarily. Corley does that same exact thing that I would do when you submit a paper and figures out the percent of matching text in the court's opinion and the two legal briefs, right? So obviously, the petitioner brief and the respondent brief. So this is Corley's way of looking for influence. If a brief sort of steals language directly, that's influence. Let me give you an example here. You see this long passage. These were written in the petitioner's brief. The middle one is the brief quoting the court itself. Okay? But the top and bottom are unique. The petitioner's attorneys wrote the searches made at the border paragraph, and the travelers may be so stopped paragraph. The middle one is quoting a previous court decision. All three of these appeared word for word in the Supreme Court's opinion on this case. So again, all three of these were written by the petitioner's attorneys, and they appeared word for word, verbatim, in the court's final opinion. Right. So this is important, right? That the first and third, or the top and bottom paragraphs, are unique to the petitioner's attorney, and the middle one was written by the court itself. Because somebody could say, oh, well, the briefs quote a lot of the Supreme Court's language, and then if the Supreme Court uses that language, they're not copying from the brief, they're just copying themselves. They're quoting themselves, and that's totally different than plagiarism or influence or whatever. But what we see here is that the first and third, or top and bottom paragraphs, were brand new paragraphs written by the petitioner's attorneys, and those also appear in the Supreme Court's opinion. So they're not just copying their own precedent. They're actually lifting stuff from the briefs. Another way to say that is they're plagiarizing unique language from the briefs themselves. They're not just copying themselves. So let's look at Corley's evidence. She looks at a small subset of cases because it's kind of an older paper, and she used Microsoft Word to compare the briefs and everything. So she looks at all of the cases from the 2002, 3, and 4 terms, somewhere in the neighborhood of 200 some cases. So she first looks at each justice's propensity to copy. Of course, different opinions are assigned to different justices. Maybe one justice loves to plagiarize and the other 8 don't. So she looks at each of their propensity to copy. So the first question is, do they even do this? Forget that example I just gave you of the 2 paragraphs. Does this happen on a more systematic level? And what you see here along the x-axis is the 9 justices that were on the court in 2002, 3, and 4. And on the y-axis is the percentage of the opinion that was plagiarized from the appellant's brief. Okay? It varies, somewhere around 8, 10, 12% in some cases. First let me make sure you know how to read these charts, okay? You see this little line here in the middle where you see my cursor? That is the average, and then the box part is the sort of standard deviation around there. These big tails are the extremes of the distribution, and these little circles are outliers. So if you look at the line within each box, that's the average percent that the justice plagiarized from the appellant's brief. So we see, Stephen Breyer's doing it about 8%. Rehnquist was doing it somewhere in the neighborhood of 12 or 13. Thomas around 10. Oh, excuse me, Stevens around 10. Thomas around, well, maybe that's 10 or 11. So yeah, they do this. It's not a huge amount. I mean, we see up here, O'Connor stole like 32% one time. Thomas has taken 28, 30% on occasion, but that's not common. They are taking a lot of information, plagiarizing, not information, they're plagiarizing direct text from appellant's briefs. It's not all of it, but 8%, that's kind of a lot. If you wrote me a 15-page essay and 8% of it was plagiarized directly, I might be a little concerned. Now, if you look at the same information, but this is for the respondent's brief, we see similar patterns. It seems that they take a little bit less from the respondent's brief, somewhere in the neighborhood of 8, 10. I think it's a little bit lower if you kind of flip back and forth. It's just a touch lower. The reason for this is because the appellant is more likely to win. I've been saying that a lot. But, the petitioner, by the nature of the appeals process, the petitioner lost at the lower courts. They're going to be the ones that appeal to the Supreme Court. Of course, what we know is that if the Supreme Court likes the lower court's decision, they don't take the case. So the appellant wins in about 66% of the cases that the court hears. So it's not a surprise necessarily to see that they'd be taking a little more direct language from the appellant or the petitioner rather than the respondent. So let's look a little more. So we know now that, justices do this, at least in the 2002 to 2004 terms. Let's look at a little bit more systematic evidence. Is it only in those years, or is only some instances? So the dependent variable here is the percentage of the majority opinion plagiarized from each party's brief. And the independent variables are whether the Solicitor General was participating. The idea is they're more likely to steal from the Solicitor General because they respect that office so much. The haves versus have-nots, the number of resources each party has. The idea there is that they're more likely to steal from the so-called Washington elite, or they're more likely to steal from a state than people within the state or something like that. Does the attorney have experience in front of the Supreme Court? Obviously, I think more experienced attorneys are likely to have more of their language lifted than less experienced attorneys. What is the ideological congruence between the brief writer? It sort of makes sense that they're more likely to steal from an ideological friend than an ideological foe. Case complexity is another one. There's a number of ways to calculate case complexity. Don't worry about that too much. But the idea is that if a case is very complex, if it has a number of legal issues, they're more likely to steal. It just makes their job easier. If a case is very easy, there's no reason to steal. Additionally, we have case salience. The idea here is that they're less likely to steal when a case is salient because they want to make their mark specifically on the law when something's salient. So they're less likely to lift verbatim language. So if you look at this very smushed table, we see in this first column here, if you follow my cursor, we have the percentage stolen from the appellant's brief, and then in the next column we have the respondent's brief. So let's kind of look through this here. So here in the first two rows, we have the Solicitor General is the appellant versus the Solicitor General is the respondent. We see here that they steal from the Solicitor General, and they're less likely to steal from the Solicitor General's opponent. So, when the Solicitor General is the appellant, right, the coefficient here is positive. Meaning the greater percentage of the appellant's brief, that is the Solicitor General's brief, makes its way into the final opinion. When the Solicitor General is the appellant, less of the respondent's brief makes it in because they take more from the Solicitor General. They're less likely to steal from Washington elite's opponents. It doesn't mean here that they're more likely to steal from the Washington elite. So if you follow my cursor here, Washington elite appellant, we see so when they're the appellant, they take less from the respondent's brief and put it in the final opinion. So they're not more likely to steal from the haves. They're just less likely to steal from the have-nots. when the haves are party to the case. Here we look at attorney experience. We see when the appellant is an attorney, or when the appellant's attorney is experienced, they take more from him or her. But when the respondent's attorney is experienced, as you can see here, they take more from the respondent. So they steal more from experienced attorneys. As also makes sense, they steal more from ideological friends and they steal less from ideological foes. We can see that here from the positive coefficient for appellant brief when the appellant is ideologically compatible, and the negative coefficient for the respondent's brief when the appellant is ideologically compatible. They're less likely to steal when the case is salient from both parties. That's consistent with the theory. Right? So we see a lot here. There's a number of reasons that they would steal from the appellant or the respondent, and it seems to be they take information from people that they deem to be credible. They deem the Solicitor General to be credible, Washington elites, and experienced attorneys to be pretty credible. Okay. Here, if we look at, let's look at the predicted percent of the opinion from the appellant's brief. So this is what percent can we expect a written opinion to be directly lifted from the appellant's brief, and this is sort of the substantive effect we're looking at under different sort of circumstances. So the baseline here, if you can see my cursor here, the baseline is like 10.5%. So on average, they're going to take 10.5% of the appellant's brief and put it. I said that backwards. They're going to 10% of the opinion is going to come from the appellant's brief. Okay. However, if you look here, if the Solicitor General is the appellant, that jumps to like 12.25%. It looks like. Okay. Similarly, if the appellant's attorney is experienced, that jumps to a touch under 12. If they're ideologically compatible with the appellant, as you can see here, that jumps to maybe 11. And if it's a politically salient case, that drops to a little under 8. So we do see that there is a substantive effect here when we're talking about these different factors. You can see these numbers summarized here on the right side. Here what we have is the likelihood that the justices or that the opinion will use more language from the appellant's brief versus the respondent's brief. The baseline here is somewhere around 60. Again, that's just because the appellant is more likely to win in the first place. But what are the different things have to do with it? So when the Solicitor General is the appellant, the probability that the opinion uses more appellant brief language than the respondent brief language jumps to almost 90%. It's almost a guaranteed thing that when the Solicitor General is the appellant, the Supreme Court is going to take more language from the appellant's brief and put it in their opinion than they will from the respondent's brief. When the Solicitor General is the respondent, the sort of opposite is true. They're going to take less from the appellant and more from the Solicitor General, right? So these two lines here are consistent. It's just that the y-axis is the prediction of using the appellant brief as more frequently. If the respondent is Washington elite, they're really not going to use the appellant's language. Another way of thinking about this is if the appellant is a Washington elite, they're going to use it's 70% likely that they're going to use more from the appellant than the respondent. Here in this second to last bar, if the appellant's attorney is experienced, 75% chance they're going to use more. And finally, in this final bar, they're going to use more language from the appellant's brief 72% of the time when they're ideologically congruent with it. So this is all just showing substantive predictions about what's going to happen. And it's just they kind of like the appellant more when the appellant's the Solicitor General or Washington. Okay. So legal briefs seem to influence the justices, at least by Corley's definition of influence. If you're looking for a definition of influence that says they totally changed their mind, they came into this knowing what they were going to do, and they changed their mind when they read the brief, I'm just not sure you're going to find it. I'm not sure you can go back to our discussion of the attitudinal and strategic models and find influence anywhere outside of ideology and strategic maneuvering. But that doesn't mean influence doesn't exist. And I think this is a really great example of where influence exists. Okay. The nature of the law, the outcome, not the vote, the thing that happens after the vote, the written opinion changes based on the petitioner and respondent briefs. And it seems that they're persuasive. So even if they don't persuade mind changing, they persuade the justices to choose a particular variant of the law. It influences the law. In short, justices plagiarize. You gotta love it, right? These are they went to school forever, and most of them are professors, and they themselves plagiarize. Now, what you should really take away from this is that they plagiarize more when they think that the source is credible or trustworthy. There's a reason that the Solicitor General carries so much influence with the Supreme Court. There's a reason some people refer to it as the 10th Justice. They curry a lot of favor. So the justices trust them. They trust attorneys that they've seen before, that have been before the court a bunch more. They trust Washington elites because they are Washington elites. They trust ideologically proximate briefs because, well, ideology is a cue for credibility. So these are some of the things that the court looks to when trying to make decisions about how what the law is going to look like at the end of the case. Well, it turns out they just lift them. They're not always coming up with new, novel ideas. Sometimes they just steal them. All right, that's it for this lesson. I'll